up for questions. Now I'm going to ask you, please, if you could keep the questions until the end of the lecture. Mr. Ramosa is not here to assist me today. There's one person who cannot, Ambani. I think it must be from your side. Please just test again if you cannot hear. Like I said, thank you so much, Tebogo. Mr. Ramosa is in another meeting today, so he will not be able to assist with answering the questions while I'm presenting the lecture. But we still have Advocate Kumwenda, and we also have Professor Dean here to help me for the queries. If they are unable to answer your queries, we will leave the queries until the end of the lecture. Okay, I'm moving closer and I'm going to increase the volume, although it's quite loud on my side already. All right. Yeah, I think, Lauren, maybe on your side. Now, can you all see the first slide, where it says Principles of Criminal Law Discussion Class Study Unit 6? Good. Now, we're just going to recap again. If you can see, this is basically, like I said, right at the beginning when we started off with these lectures, the layout of the study guide. And we're in the third column already, as you can see, that has to do with criminal liability. We have done as we had in the introductory topics, we did a very short summary of criminal liability. We've already did the act or omissions. We've done the definitional elements. Last week, oh my gosh, I think Lufono, if you cannot see this, it's probably because you are entering as a guest and not as a student. Just try and enter again, please. And last week, Mr. Ramosa started off with unlawfulness. This week, we will finish with unlawfulness. And then the next week, Mr. Ramosa will carry on with culpability and criminal capacity. As you can see, unlawfulness means without any justification, without any lawful justification. So as we know, conduct is unlawful if it conflicts with the boni mores or the good morals or the legal convictions of society. This is just a recap. And how do we know it is conflicting or it's unlawful? It's when it conflicts or with the definitional elements of that crime. And we already know what the difference is between the definitional elements and the definition, if you can still remember. And then we started to look at the grounds of justifications or as a defense, which may exclude unlawfulness. If the defense fail, then the conduct will be unlawful. And the first one, if you have a look at this, was private offence. And Mr. Ramosa completed private offence last week. I'm not going to go through private offence again. You did the requirements for private defense, which you will see when we do necessity, which is the following ground of justification. There are also requirements for necessity, and some of them are very similar to private defense. So you have to be careful to know what the difference is between private defense and necessity. The other grounds of justification that we will look at this lecture is consent, presumed consent. Now, I put a question mark behind right of chastisement because there is no more a right of chastisement if you read your tutorial letter 102. The obedience to orders can also be a ground of justification. Your official capacity, for example, police, can be a ground of justification. And then there is also triviality, and we'll just have to look at triviality because the courts do not actually consider this a ground of justification anymore. So here we start with this study unit, which is the second part of unlawfulness. It's in your study guide from pages 80 to 98. And as you can see, those are the grounds of justification, which we will discuss. You will see chastisement is not a ground of justification anymore, and the same as triviality, but we will just have a look at them quickly. I just want to tell you that for this year, you don't have to, you can actually ignore chastisement completely. We were supposed to have a new study guide this year already, but because of COVID-19, the study guide was not published. There was nobody at the main campus to actually publish the study guide. So we actually getting the study guide published this year, where the necessary amendments are made. But the amendments you will find in your tutorial letter 102, which you will find on MyUnisa under additional material. All right. Now, similar to private offence, the test for necessity is objective. Now, you already know what the difference is between an objective test and a subjective test. Subjective test is where you look at the individual from the individual's perspective. In other words, the perpetrator's perspective. What did that person think he or she experienced at that particular moment? Objective is what we call the reasonable person test. In other words, what will people, the reasonable person or the general public or the general man or woman out there, what will they think? Was it necessary or was it not necessary? Did the situation actually necessitate what you did, your conduct, or not? So that is why the test for necessity is objective. Now, similar to private offence, you can also get putative necessity. Now, putative, if you remember that word, it means that you think it is something, but it is not actually like that. It is such a certain situation where it is not actually that situation. So putative necessity is where a person thinks that he or she is acting in a situation of necessity, but it's not really a situation of necessity. This, of course, just like a putative private offence, it is not lawful, but you may escape your liability, criminal liability, as a lack of culpability. You did not have intention. Let's have a look at the definition of necessity. Now, at the bottom, I've put down the definition of private offence, which you got to know last week. And you will see that it is very similar in certain regards. So please don't get confused. The definition of necessity states that where a person acts in protection of his or her own or somebody else's life, your physical integrity, property, or other legally recognized interest, which is endangered by a threat of harm, which has already begun and is always immediately threatening, and which cannot be averted in any other way, provided that the person who relies on the necessity is not legally compelled to endure the danger, and the interest protected by the act of defence is not out of proportion to their interest threatened by such an act. If you quickly have a look at the definition of private defence, you will see that there are certain elements that are almost similar. For example, there is the attack. Okay, remember now, in private defence, there's an attack. In this necessity, there is no attack as such, or necessary. But it's already commenced, or it immediately threatens, and it's somebody else's life, bodily integrity, property, or other interests that ought to be protected by law. That's exactly the same as necessity. Then remember now, this is a defensive act in private defense, where they say it has to be necessary. And there's no such requirement in necessity. Don't worry if you think I'm going through this too fast. We will go through the elements or the requirements for necessity one by one, and that will be basically the whole definition. As you can see, the definition exists only of the requirements for necessity. And again, where private offence says that it's no more that the Defensive Act must not be more harmful than is necessary. In necessity, it says that the act of defense is not out of proportion to the interest threatened by such act. So very similar, if you agree with me, very similar definition. So don't get confused between these two grounds of justification. So what is the difference then between necessity and private defense? Now, necessity is it's the origin, where it comes from. So necessity stems from either human conduct, okay, so either from a human being, or non-human intervention, for example, chance circumstances. I'm going to explain that later on. For example, non-human intervention can be a fire or a cyclone or anything that you can think of that is non-human. For example, they have an example. They have example in the study guide with a building burning. If there is a building burning and you are on the second floor and you have to jump out of that building, else you will be killed by the fire, and you jump on top of somebody else's car, they can't say that you have damaged their property because what you did was out of necessity. Because of the fire, you had to jump out of the building and unfortunately land on their car. So that is a non-human intervention. Good. Now, private defense is only from human conduct. It only comes from human conduct. In other words, it's an attack from a human being, and it's a defensive act from a human being as well. Then necessity is, secondly, it's directed at the interest of an innocent third party, okay, or it consists in the violation of legal provisions. So if I use the ground of necessity, I can protect, okay, or somebody, a third person, a third party, for example, another person or human being, or I have to violate legal provisions because of necessity. For example, if my child is very ill, I take my child in the car and I rush to the hospital with my child and I exceed the speed limit. I did that. I violated that legal provision of exceeding the speed limit, but I did it out of necessity. And private defense is always directed against an unlawful, a human unlawful attack. So you must always remember there must be an attack. It's human on human private defense, and it is human conduct and a human unlawful attack. Now, you will already know that we discussed necessity before, and that was, I think, in study unit 2, when we did, or 3, oh yeah, study unit 3, I think, when we discussed relative force. If you can still remember, now we discussed absolute force and relative force. Now here we have it just in a different form. A relative force or relative compulsion, or compulsion or coercion, that's a different word for that as well, is always a voluntary act. Remember, that is where a person can still choose whether he or she wants to sacrifice their own life and do what the person says or not. So that you have to choose between two evils, and that is relative compulsion. Absolute compulsion, there's no voluntary act at all, because you can still remember that example that I gave about the big person, the big man holding the tiny little girl from behind with putting a knife in her hand and stabbing somebody else. That tiny little girl cannot act at all. There's no voluntary act there. So this is, again, just to show you that it all it all works together in this guide. We have already spoken about absolute and relative force or compulsion, and here we get it again. And with relative compulsion, necessity only qualifies with where the person can still choose between two evils. We also discussed in that study unit a case. If you cannot remember, the case law was Goliath. State versus Goliath. And just to quickly sum up again for those persons who can't remember the Goliath case, Goliath was forced by the main perpetrator, or X, to get hold of a third person to hold him so that the X could stab him. And Goliath was unwilling to do this, but the X said to him, if he doesn't do that, if he doesn't hold the third person tightly, or Y tightly, he will kill Goliath. And Goliath had to hold this person, or he would have been killed. So the court ruled that this was an act of necessity, or he acted under compulsion or coercion. He was forced to do what he did. So he could rely on the ground of justification called necessity. Good. Let's quickly see what are the requirements for necessity. And you will see this is exactly the same as the definition. It's basically just split up now and to show you that these are the requirements. The first of all, there must be a legal interest threatened. So that is either, like we said as well, it's either a violation of a legal provision or the interest of a third person. You may protect another person. In other words, you don't need only to protect yourself, but you may protect another person, a third person. The emergency must have begun, but not yet be terminated. That's exactly the same as for private offense. You may even rely on necessity if you were personally responsible for the emergency. For example, say that person who jumped out of the second floor building actually put the, was responsible for the fire by an accident in the kitchen or something like that. So you may even rely on necessity if you were personally responsible for the emergency. But you may not rely on necessity if you are legally compelled to endure the danger. This refers to, for example, police persons. I mean, they cannot rely on necessity in a situation because they are legally compelled to endure the danger in their type of work. But it must be the only way in which to avert danger. If there was another way in which you could avert the danger, then unfortunately you cannot rely on the ground of justification called necessity. Here again, you must be conscious of the fact that the emergency exists. That is just logical. I mean, you're not going to react to something if you're not conscious that the emergency exists. You must not cause any more harm than necessary, similar to private offense as well. And we've already discussed this. Can necessity serve as a defense to murder? Yes, you can see, for example, in the Goliath case. Now, another case that's in your study guide is the Mayimela case. I just quickly want to tell you what happened in that case. In the Mayimela case was at a mine, occurred at a mine. There was a strike at the mine, and the person working for the Makado municipality, the manager, supervisor, he went to the striking workers trying to organize a meeting for them so that the strike may end. But unfortunately, he was attacked by some of the workers. He fell to the ground. Fearing for his own life, he shot just 3 2 or 3 random shots into the air. But unfortunately, 2 people, one person was wounded, another person died because of these shots. And the court decided that he may rely on necessity, because in these types of circumstances where you are fearing for your own life, where you think that these people are going to kill you if you don't do something to save your own life, necessity can work as a defense of work as a defense. Why? Because in these types of circumstances, I mean, there were more than 300 striking workers with knopkeries. He had acted reasonably. Remember, we said about we talked about the objective test. Yeah, the court actually tested the situation, the circumstances in which this person was objectively, and they said that they think that other people in the same situation would have reacted exactly the same. He had a right to his own right of life, and to deny that person the right to act in circumstances of necessity by killing somebody else to protect his own life would actually be to deny that person his right to life. So that is the Maimela versus Makado municipality, and another that you must please have a look at that when it's in your case law reader. It's a very interesting case as well, and I mean it's a situation that we get so many times these days in South Africa. So a very applicable situation. Right, let's move on to consent. Now, consent is that is in the new SNAIMON, the last 7th edition. That's on pages 102 to 106. Consent is just what it says. Somebody gives you permission, okay, to do something. But it has to be voluntary. That's the first thing. If you are forced, just like some of you, remember some of you are doing CRW2602 specific crimes with a rape, which you did, I think it was the last lesson that you did. If you are forced to do something, or then it cannot be voluntary. It has to be voluntary. They give an example here of a case. It's not a prescribed case, of a I can't remember what is the what he was at the Air Force. He was the ground general, or the general manager for the airways or whatever. It's the McCoy case. Sorry, I'm still busy with consent. Who is it? Vuvaivo. And it's a terrible, I know it's a Chivenda name, Hazel, but I'm still busy with this slide. Oh, you mean if somebody can upload it? You can see the slides, eh? Okay, let me just quickly, sorry guys, just a moment, please. Okay.
Thank you. Thanks. Bye.
Sorry, students, that was just Professor Dean. She's been cut from the lecture, and she's having problems accessing the lecture again. So I'm very sorry about that interruption. She's going to try. Yeah, Olwetu, the no sound is because I muted myself while I quickly spoke to Professor Dean, but obviously there's sound now again. Lihlogonolo, I will try and share the slides before presenting them. Mrs. Zeng, thank you so much for uploading that slide. You are a darling. I really appreciate your assistance there. All right, we were discussing the McCoy case. And the McCoy case has to do with voluntariness because the air stewardess, in this case, the air stewardess forgot to actually put on her seatbelt when they landed. And this was obviously in contravention of one of the rules that they had. And the general manager said that he will not fire her if she allows him to give her a hiding. Now, obviously, she allowed that because she wanted her job and so on. But after he gave her hiding, he was charged with assault. And the court ruled as well that it was assault because consent, if you consent to something, it has to be voluntary. And she was forced to consent to this, else she would have lost her job. So that's an example for voluntariness. Now, obviously, oh, there we go. Welcome back, Professor Dean. It has to be given by a person with certain minimal mental abilities. You must be able, you have to have a criminal capacity to know what is right and wrong and to be able to distinguish between those two. That is the certain minimal mental capacities. It must be based, your consent must be based upon the true and material facts, knowledge of that. And this is exactly the same as in the lesson that you had on rape. In other words, it must not be in an error in negotiation. That's a type of act. In other words, you think that this is a certain type of act, and in essence, it is not. And this, for example, is, and I'll illustrate it with rape as well, where the person thinks that the doctor is doing some or other procedure to help her with her infertility, and all the time he is actually having sexual intercourse with the person. So there's a confusion of the type of act. Or the error in persona, that is now the identity of the person. And I think in this study guide, we also have the case of C, which is also in the study guide for CRW2602, where a lady thought that the person who jumped into bed with her while she was sleeping was a husband, and it was not her husband, but she had an error in persona and had sexual intercourse with the person. So she did not have the true and material knowledge of the true and material facts. Now, another requirement for consent is that it can be given expressly. In other words, you can say yes, no, or you can write it down in a contract, or tacitly. In other words, you can basically just give a nod to indicate that you agree. It has to be given before the commission of the act. Now, that, of course, it is logical. I mean, how are you going to consent to something after it's already happened? So before something happens, you give the consent to that act. And it must be given by the complainant, or him or herself. It cannot be given by another person. You cannot, the mother and father cannot agree or give consent to something that the child does not consent to. The child, him or herself, must consent to that. So here we go on. So what possible effects can consent have? In some crimes, consent is not a ground of justification, but it may form part of the definitional elements. Now, can you think of an example there where it is part of the definitional elements? If you think about rape, that one part of the definition is that it is sexual penetration. It's unlawful intentional sexual penetration with another person without that person's consent. So there you can see that consent is part of the definition. Oh my gosh, it got kicked from the meeting, so sorry. Consent forms part of the definition, the definitional elements. Another crimes, consent is never recognized as a defense. And here, for example, we can think of the murder. You cannot consent to being murdered. And if you think about, and I think that Mr. Ramosa mentioned the Stranson-Ford case, which had to do with a mercy killing or physician-assisted euthanasia. The court first, in the first court, said that mercy killing, and we all know what mercy killing is to basically terminate the life of somebody who's terminally ill out of the compassion for that person's sufferings. That is mercy killing. So it is not a justification against a charge of murder. So even today, this decision was, the initial decision was overturned, and they said that no physician, no person has the right to end another person's life, and common law has to be developed, has to be allowed to be developed to allow for this physician-assisted euthanasia. The courts cannot decide this, you know, they cannot just change this. So yes, it is, that is murder, and that consent is never recognized as a defense for the crime of murder. There are crimes, for example, where consent can operate as a ground of justification, for example, in theft or malicious injury of property. Now, if you can remember, if somebody agrees that you, for example, take something, then, I mean, there's no theft or there, but consent can operate as a ground of justification in certain crimes. And there are crimes where consent can sometimes serve as a ground of justification and sometimes not, such as in the case of assault. Now, that one is quite easy if you think about a doctor, a physician or surgeon who has to operate on you. In other words, if you think about what he's doing, he's actually doing assault, because he is cutting your knife, or he's cutting you with a knife, but you have consented to that. So consent there serves as a ground of justification in the case of such type of so-called assault. Oh, glory. There we go. And again, to determine whether, let me just quickly go on. Can you see that? To determine whether consent excludes unlawfulness, we should again apply that right at the beginning, that Winnie Morris of Society, the public policy test criterion. What would the the general public and the morals of the public, how would the public feel about this? Okay, now again, there's the doctor's one. Can you think of example where consent can justify, in other words, act of assault? And it's basically, as you can see there, with a little picture that we've drawn, where a surgeon or a doctor is operating on a person. Now, in your study guide, you have to look at, yes, you're right, sports too. Very well done. Exactly. What is presumed consent? Now, you have to look in your Snyman for the definition and the information in Snyman. But I'm just quickly, presumed consent, I'm just quickly going to summarize it for you. And I think the next slide gives you the requirements for presumed consent. But presumed consent is basically just saying that you acted with necessity because you thought that there would have been consent in that emergency situation. For example, if somebody, an ambulance driver, picks up an unconscious person and drives that person to the, yes, absolutely. Negotiate. Who is that? I can't even see who it is, but that is exactly what it is. That means unauthorized administration. Or spontaneous agency as well. Where the ambulance driver transports that unconscious person to the hospital, he did not get consent from that person to transport that person to the hospital. There was presumed consent. Okay, else it would have been, that person, the ambulance driver, could have been charged with kidnapping, because, I mean, they're taking a person. That such consent is presumed. The same, if that person arrives at the hospital and is still unconscious and it's a life-threatening situation, and the surgeon performs an emergency operation on that person, there's presumed consent. All right. Now, presumed consent in certain situations, in religious situations where certain religions do not want blood transfusions or operations or so on, it's very difficult. But somebody like a surgeon always presumes where the person cannot act, or, you know, the person's unconscious or cannot give consent, there's always presumed consent. Now, okay, there we go. Now, again, presumed consent requirements are quite logical. Again, the first one would be, there must be reasonable grounds that Y would not have objected. So again, if a person is lying on life-saving machines, but there's no brain function or whatever, and and they presume that Y would not have objected to having the machine switched off, there must be reasonable grounds. If Y has put in their will or whatever, that they, in such situations, they should not have the machines switch off, they will not be presumed consent. Good. The reasonable grounds must exist at that time of X's conduct, when the X performed the operation or whatever. X must be aware of the reasonable grounds, and X must intend to further Y's interest. X's intrusion must not go beyond presumed consent conduct. Only that which is necessary for that situation is presumed. X's act does not need to succeed in furthering Y's interest. In other words, X must just further Y's interest. It doesn't need to go above and beyond, just helping Y. And then it must not be possible for Y to obtain Y's consent in advance. In other words, if X could have contained Y's consent in advance, there's no presumed consent. Now, this again, like I said, is just a very short summary from Snyman, so that you have something from this textbook, and you don't need to actually go and read it there. Good. Now we do to the right of chastisement. Now, just quickly to tell you again that you do not need to know this. This is just a little bit background for you, just to, because we are getting quite a lot of queries about why is it still not in study guide, and we have to keep on answering to say, please go and read your tutorial letter 102, where we actually tell you not to study it. We have updated it, but you don't need to do it. So the right of chastisement was, in terms of the common law, a parent or a teacher could hit a child or punish a child, give a child corporal punishment, only if that punishment was moderate and reasonable. Now, that is completely fallen out. Teachers no longer have the right to impose corporal punishment. That was in the case there is in the Christian Education South Africa versus Minister of Education 2000 case, as you can see there. Section 10 of the South African Schools Act says it's a violation of the constitutional rights of a child. So that's just a quick background. And then after this case, parents still had the right to impose moderate and reasonable punishment on a child. But that also fell away with the YG versus S case. They said in this case, and I'll just quickly, the case is summarized in, if it's in your tutorial 102, sorry, where YG, which is now with the perpetrator, the father, was charged in the regional court with assault to do grievous bodily harm in respect of his 13-year-old son. Obviously for what he thought was reasonable corporal punishment, he had caught his son using one of the family's iPads, and the father accused the son of watching pornographic material. And despite the son denying this, he struck his son quite a few times. So the court ruled there that the defense of right of chastisement, or this defense of reasonable and moderate parental chastisement, undermines a child's dignity and the child's right to physical integrity. That's all I'm going to say here, because as I say, you don't need to know this, but this is for just background for you guys. All right. Obedience to orders. You can use, this is a ground of justification where you can basically say that you had to do perform the act or the conduct because you were obeying an order by a superior. So what you need, and this is Sneyman and from page 134 to 136. But you have to remember that no member of a security service, and a security service means police, anybody that has to do with security, may, but no member may obey a manifestly illegal order. So if an order is illegal, you have the right. In other words, it's unlawful. Okay, you must go and kill so and so. It's an unlawful order. You have the right to say, I will not do it because it's a manifestly illegal order. And as we say, that it's usually applied to the military, but it's not restricted to only soldiers. And there we have the Mostert case, the S with this Mostert. And that was a case involving traffic officers. The one traffic officer was told by his superior to go and fetch another traffic officer at home. The other traffic officer at home did not want to come along. So the one who forced him to come along by punching him and calling him abusive names, and he was charged with assault and criminal injury because he called the other person terrible names. But the accused was Mostert, said that what he did because he was obeying the orders of his superior, and the court did not agree with that. So as you can see, there are requirements for obedience to orders. The first order must emanate from a person in lawful authority over the accused. In other words, it must be a person who is your superior, and you acknowledge that person as your superior. The accused must have been under a duty to obey the order. In other words, do you need to obey this order or not? How do you test that? Was this order unlawful manifestly or palpably, which means was it completely unlawful? And if it was, then you don't have a duty to obey that order. The accused must not have done more harm than necessary to carry out the order. Again, like we had in the Morstead case, the Morstead was just ordered to go and fetch the person. He was not ordered to assault the person and swear at the person in order to force the person to come to the office. So there's no more harm, more than necessary. Okay, almost finished. Official capacity. Now, official capacity is, again, just like we have a little traffic officer there or policeman. Is if you, for example, had to arrest somebody and you use force, you can use the ground of justification, saying that it was necessary because of official capacity. It was a ground of justification of official capacity. So for what is official capacity? An act which would otherwise be unlawful is justified if X, by virtue of holding a public office, is authorized to perform the act, provided the act is performed in the course of the exercise of his duties. That is the official capacity. As we said now, for example, the police trying to arrest someone, or even security personnel doing searches where they, for example, damage your house or in trying to do a search. Oh, okay, and that was the last one. Now, again, students, remember that these notes are just supplementary, that your study guide and your reader and textbook remain the primary source from which to study, and thank you so much. I'm now going to open up for questions, and I just want to see, let me just quickly, okay. All right. Good. If I can just get the participants, Tameshni, I have quite a few hands up. I'm going to start with Sizo Sitole. Sizo, I'm going to do the hands first. I know that there must be questions from the chat as well, but let's try and do the hands first and see whether you can actually, if you feel that your question wasn't answered in the chat, then you can just ask the question by raising your hand, and we will try and answer your question. Now, Sizo, can you, and I must say things have changed on this PowerPoint like nothing. Can you unmute yourself or just ask your question? Sizo? All right, let me just go on. Sizo will come back to you. David? Oh, there we go. Hallelujah. I'm so glad it's working. Hi, David.
Hi, good afternoon. How are you?
I'm all right. I'm on sick leave actually, but now I had to give the class.
Oh, okay. I think first let me welcome and appreciate a well comprehensive lecture for this unit. My question basically is just around the necessity.
Yes.
When you introduced the topic of necessity,
Yes.
of course you gave a very good example where you said like when your child is sick,
yes,
you can just pick the child, and then you can as well just perhaps you drove through the red robots or over the speed limit, then you can raise that as a necessity
yes,
in your defense.
Yes.
But now, I just want to check as to whether necessity is it has to do with the human threatening life situation. And I will tell you why I'm asking this. I think it is also because of, we also have that case of Fori, who happened to be a magistrate, and he was running very late. He drove through the over the speed limit, and there were some court cases. But I'm trying to make a good logic here based on the two scenarios. So to suggest whether it has to be a human threatening situation.
Okay, David, very good question. But remember now, that is why we have the requirements. You have to actually go and test whether this particular situation abides to all the necessary requirements. If you think about Fourie, he was late because of his own how can I say, negligence, isn't it? And that's what the court also said. He made use of this necessity and said it was necessary for him to go actually get to work, to go and go to court. But he could have, like the court said, he was responsible for his own situation. So, you know, he could not rely on necessity for in this type of case. If you think about the example that we gave about the child being rushed to hospital, that's a life-threatening situation. So you have to use the objective test here as well. Like we said, that if the reasonable person thinks that, you know, the necessity was the emergency. The necessity was applicable in this situation, then it will work. Otherwise, they will not give the necessity. Even that example, for example, Mostert now that we gave, that used the last one with the obedience to orders. Was it obedience to orders? Yeah. You know, he could have said it was necessary for me to do it, but in such cases, it's not. He basically caused more harm than was necessary as well. So I don't know whether that answered your question there, David. You know, there are other ways of, for example, for Renau, who could not rely on necessity. He could have woken up earlier. He could have, you know, done many things to get to the work earlier and not use that as an excuse, you know, exceeding the speed limit, using his work as an excuse. But you can think that if you want to try and save your child's life, you will do it by any means possible, even if it is, you know, exceeding the speed limit. Did that answer your question, David?
Okay, thank you very much, Professor. It makes perfect logic. Thank you very much. I appreciate it.
Again, David, I just want to remind that if you have any further questions, you are more than welcome to email us. We have quite a few people emailing us and asking us additional questions. All right.
Oh, okay. Thank you.
Thank you, David. Bye. Good. Noko. Noko. Noko, can you unmute yourself? That microphone that's on the top right, just press it so that that's unmuted. Okay, I'm sorry, Noko, I'll have to move on. Let me just disable. Okay, Nkosana, Kuluva. Nkosana, do you have a question? Oh my gosh. All right. Mandisi, you are next, my dear. I'll go back to the others. Mandisi? Guys, I think it's going to be a chat session and not a verbal session. I'm so sorry. I don't know what's going on. I'm going back. I'm going to Gertrude. Gertrude, you can unmute yourself. There we go.
Hello, can you hear me?
Yes, of course, loud and clear, Gertrude.
Okay, so my question is on the part of consent.
Yes.
I wanted to ask if can a person withdraw consent during intercourse? Can that be regarded as rape? Let's say, for
Yes.
instance, during intercourse, you are experiencing unbearable pain during
Yes.
threshold by vaginal stimulation. Or
Yes.
can that be said that the criticism is that it's impossible to define a reasonable amount of time for the partner to stop the act, that is the
No.
sexual intercourse after the
No.
withdrawal, ne? So
Yeah.
my question is that can you withdraw the consent and your partner, let's say, doesn't stop? Is that regarded as rape?
That is rape. The law is loud and clear on rape. Anytime when you withdraw your consent from the act, whether it's before, during, or whenever, okay, if you say no, I do not want to be sexually penetrated, and there's no consent. And remember, consent forms part of the definitional elements here. So that is rape. So if you ever get a question where it says that, this is why your scenario, and the victim Y says, I don't want to have sex anymore, and the person continues, it's rape. There's no more consent.
Okay.
Okay, thanks, Gertrude.
Thank you.
Thank you, my dear. Okay, I'm going back to Nkosana. Nkosana, I'm going to unmute you. Nkosana? I know that you guys have problems with unmuting yourself sometimes. If you think even Professor Dean had so much problems today with her computer. Like I said, I don't know what is going on with with the computers. David, I see you have another question, but I'm going to, yes.
It's Mandisi here. Can you hear me now?
Mandisi, there you
Yes.
through. How are you, Mandisi?
Prof, I'm okay, thanks. I hope you are well. Please get better, Prof.
Oh, thanks, my sweetheart. I had an operation.
Oh, please get better. Prof, I wanted to ask. I read a case
Yes.
of a tax practitioner. He was doing work for a construction company submitting VAT returns, right?
Yes. Yes.
Obviously, when you're a tax practitioner like I am,
Yes.
I submit returns randomly. Sometimes clients don't have to tell me that Mandisi do X, right?
Yes.
Because I
Yes.
presume that I've received
Yes.
consent.
Yes.
But this lady was then convicted because he had submitted returns without getting prior approval. Obviously, she had prior approval. That's why that company was on her tech practitioner's profile. So we are submitting probably randomly because she knows she has consent that she once received. So now as I'm reading this now, my mind now is like cracking because I'm not sure because I thought she had presumed consent, but I'm not sure what's happening because I thought she had consent. I'm also now worried about myself that sometimes maybe SARS might come after me.
Mandisi, I must tell you that I don't have much information about your type of work. But if you think that she has consent, okay, she couldn't have done without consent, then I think you're already quite covered because your work, like I say, do include presumed consent that you may do what you must do, isn't it?
Yes.
So I think you are covered, my dear. Else we will get you a very good lawyer.
Thanks, Prof. And Prof, just in passing, also on presumed consent.
Yes.
Let's say it's me, Mandisi, and I have my wife, Regina, whoever.
Yes.
And then me and my wife, we know for the past 20 years, maybe 6 o'clock or whatever, every day, we do our thing and then we talk, whatever.
Yes.
But now, obviously, because I'm used to that thing, then let's say this week, Friday, I then do not ask that Regina, our 6 o'clock session.
See, Mandisi, if Regina doesn't object, you have presumed consent. Okay. If she doesn't object, but just like we had with Gertrude, as soon as Regina says, no, Mandisi, not tonight. Okay, then it's a no, my dear. Then Thank you, Mandisi. Bye.
Bye.
All right. I so want to go back. Let's try Tandiwe first, and then we'll go back to the others. Tandiwe. Mazinho, teeth.
Good evening, Prof. Can you hear me?
Yes, I can hear you, Tandiwe.
Okay, Prof. So my question is regarding consent. So you said that there are crimes where consent can operate as a ground of justification, such as theft. Now I am very worried or very confused, let me say. Is it possible for me to consent somebody to take my property away and then raise that as a ground of justification? I don't know if that makes sense, or maybe try to explain.
No, I agree with. I understand what you're trying to say there. Yes, theft can, for example, if you take, for example, I'm just saying now, say there's a flood in your neighbor's, and your neighbor's not there. Your neighbor asked you to take care of the house, and you know that the neighbor has a very expensive item that he said you must please just take care of this item, and you see the flood will affect this item in his house. Say for example it's jewelry or whatever, and you go and take the item out of his house before the flood comes. The neighbor cannot now, that's an emergency situation. You would have been charged with theft because you took the item from his house, but you have, it's an emergency situation, and there you have the consent of that person. So he cannot charge you with theft. Do you understand that?
Okay, I do understand, Prof. Thank you so much.
All right, Tandy.
All right, I'll get well soon, Prof.
Okay, my darling. Nogo, shall we try you again? Nogo? Nothing. And we're going to, I think, did we do Nkosana? Did we do you? Do you want to try again, whether you can unmute? All right, guys, it doesn't seem like these two guys can unmute. So I'm going to ask them to please write me an email to ask their questions, and I will make sure that I fully answer their questions. I'm going to ask whether we can end for now on these two, on this note, and that if you have any more questions, that you just communicate with your lecturers. Please don't be frightened if you get an out of office reply from me. Like I said, I am on sick leave, but I will still answer all your emails. Don't you worry. I just want to thank you each and all for being absolutely wonderful students. We are enjoying you so much. I hope you're enjoying these lectures like we are enjoying them. And remember that next week it will be Mr. Ramosa again, and he will be talking on culpability, which is the next element of criminal liability. Thank you so much, guys, and have a lovely week further. Goodbye.